Hi, everybody. My name is Jaime Wisegarver, and I'm here with my colleague, Andy Sherrod. We're members of Hirschler's employment law team. We're here to talk about the new Virginia workplace permanent COVID-19 rule. Last year, Virginia became the first state to enact temporary COVID-19 emergency workplace standards. You may remember that Andy and I did a Counsel segment on those back in July, so go back and check that out if you missed it. Just last week, Virginia became the first state to approve a permanent COVID-19 workplace safety standard, which sets the stage for Virginia to become the first state to enact this permanent rule requiring employers to take some steps to protect their workers from COVID-19. The permanent rule is going to go to the governor for review, and then it'll take effect upon publication in the Richmond Times-Dispatch. The permanent rule also means that the worker protections will continue even after the temporary standards expire at the end of this month. Overall, the permanent rule is really similar to the temporary standards, but there are a few key differences that I'd like to highlight for you. First is that under the temporary standard, employers had to contact the state health department to report every single positive COVID-19 test. In the permanent standard, the notification requirement has been scaled back a little bit. Now employers only have to contact the state if they record at least 2 positive cases in 14 days. Second, the permanent rule eliminates the test-based return to work requirement, and now returning to work is based on timing. For a symptomatic employee, that person needs to wait 10 days from the date of the onset of the symptoms with 1 symptom-free day. And someone who is asymptomatic, that person needs to wait 10 days after the first positive test to return to work. No enforcement actions are going to be brought against healthcare providers or other employers who are making a good faith effort to get PPE but can't do so because of short supply. And lastly, face shields are not considered a face covering. They can only be worn if a face mask cannot be worn because of a medical condition. So Andy, tell us a little bit about the practical implications of the permanent rule and what employers should be thinking about and doing as a result of these changes.
Sure, Jamie. I know a lot of Virginia businesses were probably thinking, here we go again with this, this permanent standard, but I would say, don't panic, first and foremost. If you've been complying with the emergency standard, you're mostly home free in terms of complying with the permanent standard. But there are some to-do lists. I would say first and foremost, think about the goal of this standard in the first place, and that is to assess the risks that are present in your workplace for your various positions. And so I think with the adoption of this permanent standard, now is a good time for businesses to revisit their risk assessments and make sure that they properly classified all of their job roles as low, medium, high, or very high risk. Once that is done, if you are a business that was subject to the requirement of having to prepare a written infectious disease response plan, now is also the time to update that document to make sure that you are accounting for the new tweaks that you mentioned, Jamie. Also, this is probably a good time to update your training for your employees so that they are aware of these new requirements and how your company intends to meet them. On the training front and also on the response plan, businesses may have noticed that on the DOLI website, they had a number of template documents related to the emergency standard. And I suspect that they will probably prepare some documents that are similar for the permanent standard. So be on the lookout for that. But I would say that, make sure you still seek counsel in preparing these documents, because we did observe a number of occasions where the DOLI's templates went beyond what was actually required under the standard itself. Next, Jamie, I would probably just say, there's been a lot of discussion in the workplace environment about vaccines and vaccine protocols, and this standard really doesn't address vaccines at all. And so, if you've gotten your workforce vaccinated, that's not going to be a silver bullet for complying with these standards. You still need to meet all the requirements, even if your workforce is vaccinated. Finally, Jamie, I would just say, employers should remember that the anti-retaliation provisions are still in effect under this permanent standard. So if your employees have questions or concerns about COVID-19 workplace safety under these new requirements, got to make sure to take those seriously, and obviously do not take any adverse action against the employees for bringing those concerns to your attention. But by and large, Jamie, I think that, as we said before with regard to the emergency standard, if you are complying with the CDC guidance and doing your best in a transparent manner to make sure that your workforce understands that you value their safety and are taking all the steps that you can to avoid COVID-19 outbreaks at your facility, that's going to go a long way to avoiding retaliation claims.
Andy, that's very good advice. Thank you. To our listeners, if you have any questions about the new permanent standards or any other employment law related questions, please feel free to reach out to us here at the Employment Law Group at Hirschler. And thanks for watching.